It's another brand new week, and this is Business Morning. Thank you for joining us. I'm Chimeze Obi Iwagu. President Muhammadu Buhari on Friday signed the Companies and Allied Matters Bill 2020, recently passed by the National Assembly. This replaces the Extant Companies and Allied Matters Act 1990, introducing, after 30 years, several corporate legal innovations geared towards enhancing ease of doing business in the country. For more on these and better understanding, I'm being joined by the Vice Chairman, Law Practice Management Committee of the Nigerian Bar Association, section on business law, and of course, he's also the Managing Partner, Aidan Solicitors, Kunle Ajagbe. And of course, I have in our Abuja studio the Chief Executive Officer and Registrar General of the Corporate Affairs Commission, Mr. Garba Abubakar. Thank you very much, gentlemen, for joining us on the show.
Thank you very much. Good morning.
Good morning. All right, let me start off with you, Mr. Ajagbe. What do you make of the new CAMA law? 15 of them introduced. How does it address concerns of commercial lawyers like you and, of course, investors?
Okay. As a matter of fact, the fact that the Companies and Allied Matters Act has been recently reenacted is a welcome development. It's taken quite a long time. And I must immediately correct that it has much more than just 15 innovations. There are countless, and I'm not so sure time will permit us. But there are two things or three things that makes it particularly welcomed. One is the fact that this is the law in Nigeria trying to play catch-up with the various developments that have taken place in company law and practice. Secondly, the law is also trying to play catch-up as far as technological developments are concerned. And lastly, too, is the fact that the new act, the Companies and Allied Matters Act, is an indication of the government's willingness to walk the talk of the ease of doing business. So it appears to tick those boxes, but it does contain quite a number of interesting and innovative provisions.
Right. Okay, Mr. Abubakar, let me come to you. What makes this new signed CAMA different from the old document from your perspective?
The new law has 870 provisions as against 612 in the Repeal Act. Out of the 870, 167 provisions are completely new, while 91 modified some of the sections in the former law. We have two new legal entities and entity types that have been introduced by the new law. We have limited liability partnerships and limited partnerships. These were not part of what we had in the 1990 Act. Other things, as my colleague said, relates to issues surrounding the ease of doing business initiatives. Modifications have been made to extend to some of the provisions of the former law to allow any individual to register his company without having to go through any lawyer, accountant, or chartered secretary. And we have robust provisions now on incorporated trustees, matters dealing with associations that are registered under Part C of CAMA. As I mentioned in some of our earlier engagements, the provisions of the 1990 Act, as it relates to incorporated trustees, was strictly based on what we had in the Land Perpetual Succession Act. No change was made to the provisions of the Land Perpetual Succession Act. What we did in the course of the review, the reenactment, was to borrow a lot of provisions from the Charities Act of the UK to strengthen the legal framework for incorporated trustees. Then on companies, we have issues surrounding independent directors for public companies, because companies have been relying on the provisions of the Corporate Governance Code to appoint independent directors. Now, this has been codified by the new CAMA, and the CAMA has also defined who is an independent director. So the debate as to who is an independent director has been solved. There are, as I said, 167 new provisions, and is nowhere close to what we had before. But typical of every human endeavor, this cannot be perfect. It's only God's law that is perfect. And our journey has to be gradual. What some African countries did was to adopt the English Companies Act wholesale. We didn't do that in Nigeria because we believe our journey should be gradual. We should put provisions that are consistent with our current state of development as a country. in the UK today, you don't even register any share capital. And you don't even register the objectives for which a company is being established. The presumption is, since a company has the powers of an individual has unlimited capacity, so he can engage in any activity. We didn't adopt that practice in Nigeria. A company still has to file its memorandum showing the objectives for which it is being established. So there are whole gamut of new provisions that will strengthen the legal framework and that will actually boost the economy.
Okay.
Thank you.
All right. Yeah, Mr. Jabwe, let me come to you. How does this CAMA law align with the provisions of the Financial Reporting Council?
Well, thank you very much. Yes, it does align with the provisions because, for one, there's a greater emphasis as far as the New Companies and Allied Matters Act on corporate governance, particularly as regards public companies. And it is obvious that from the Financial Reporting Council, that has been a major thrust of its emphasis. So I see the current provisions of the New Companies and Allied Matters Act as strengthening the intentions of the Financial Reporting Council Act.
Okay, Mr. Abubakar, let me get back to you. With this law in place, what are your expectations from the corporate organizations and the investing public in general?
Our expectation is we have a new legal framework that is robust, and companies should take advantage of some of these new provisions, particularly as it relates to disclosure, because matters relating to disclosure in financial statements, issues of duties or responsibilities of directors, even the insolvency framework that we have. Under the former law, the insolvency framework was more or less a hostile process. It's usually at the mercy of the lender. When a company is insolvent, the company hardly has any chance of coming out based on its own terms and arrangements. With the new law, there is a provision on company voluntary arrangement that allows the company to approach the court to appoint an administrator that will manage the company without the involvement of the lenders. And in doing that, you are preserving jobs because the lender is not the only stakeholder. You have the shareholders, you have the employees. So if that arrangement is approved by the court, at least it will safeguard their company and ensure that it is managed to profitability in a manner that whatever is borrowed will be repaid in a timeous manner. So directors and shareholders should take advantage of these provisions, and they should try to understand this law. We are going to constitute committees to come up with implementation guidelines, to come up with regulations, particularly as it relates to our articles of association. And what we are going to do differently this time around, these committees will not just be in-house. We'll co-opt people that are in the field, lawyers, accountants that are versatile in company law, and issues relating to financial statements. We will have a technological interface where companies will file their financial statements directly with C.A.C. The issue of paper filing will be eliminated very soon. So, as I said, we need to understand this law. People should take advantage. As soon as it is gazetted, it will be available for people to read. And we don't have the monopoly of knowledge and wisdom in C.A.C. So we rely on practitioners, company law lawyers, business lawyers, and other practitioners moving forward. Thank you.
Like Mr. Jabwe there. Okay, Mr. Jabwe, let me get back to you. The Act introduces limited liability partnerships and limited partnership, which combines flexibility and tax status of a partnership with the status of limited liability for members of a company. How does this encourage startups?
Okay, very good. It does encourage startups in a tremendous way because, for instance, if you take the nature of a limited liability partnership, it gives to a startup, a business person, many of the key benefits of a limited liability company. And it affords him that chance of, it removes the fear that his liability is unlimited, which is a major impediment for that young entrepreneur who is bustling with ideas, but at the same time, because of certain constraints that he has, if he were to incur a liability, he could be reduced to zero at the onset. So a limited liability, to break it down, it gives him that level of protection. But it's not just for startups alone. Even professional services firms like lawyers, like accountants, and a host of others are in a better position to work more professionally, and it's in accordance with best practices worldwide now. So whether you look at it from the point of view of a startup or an already existing firm of professionals, it's helpful. Even in the financial services industry, this is a brand new corporate vehicle. Lagos State had introduced it before by its own law, but it had not gone nationwide, and it's a big step forward that the CAMA has done this. So that's a major tick going forward as far as the innovations being presented by this act is concerned.
Okay, Mr. Abubakar, let me come back to you. Now, will this act foster corporate governance in a company, considering the varying amendments across public and private companies?
Of course, very well. It will foster corporate governance. As I have said, there are new innovations, particularly as it relates to public companies, the issue of independent directors. Under the new law, you have a minimum, a public company must have a minimum of 3 independent directors. So this has been codified. They don't have a choice than to comply with the provision. These are some of the provisions in the Corporate Governance Code issued by the Financial Reporting Council. Although the code has gone further to talk about independent executive and other things, but at least we have a minimum acceptable definition based on what is obtained in the law, not just regulation. Other issues relate to duties and responsibilities of directors. There are more robust provisions now in the existing law, and it will ensure accountability, because the whole essence of corporate governance is to ensure accountability and to provide the medium through which companies will be better managed. So directors will be accountable for their actions, and they will be accountable not just to the company, but also to the commission, because if they have a fiduciary relationship to the company, and they have to disclose where there is any conflict of interest involved. So all these provisions have been strengthened, and in the event of any breach, the law has provided for the establishment of an administrative proceedings committee by C.A.C, which will be chaired by the Registrar General. Some of the disputes that we used to have can now be managed administratively through mediation. Companies don't have to go to court in some of this, to resolve some of these disputes. So, as I said, there are whole gamut of provisions that we cannot actually exhaust at this sitting. But it will actually strengthen the corporate governance framework for our companies.
Absolutely. Okay, Mr. Jagbe, let me get back to you. As a lawyer, what are company secretaries telling you mainly about the fact that it's now optional for private companies to have a company secretary and for small-sized companies to hire audit firms at their AGMs?
Okay, there are 2 sides to that, and I'm happy that you raised this question. For small companies, for managers and promoters of small companies, it's a welcome piece of news, because from a purely financial point of view, it means that they may not have to use the services of, or they are no longer obliged to engage a company secretary, as was previously the case, and that may mean that they can save some money. So that's a plus for them. However, looking further down the road, even though they are no longer mandated or obliged to appoint a company secretary, to the extent that compliance as an overarching obligation of every company, small or big or mid-size, is a continuing activity. So even if small companies do not have a company secretary anymore, they still need to engage with the services of a professional advisor. I must say, in this case, a lawyer, to ensure that they are on the straight and narrow path of compliance. But for business owners, yes, this is good for them. I'm sorry, please, what was the second question?
Hello?
Yes, sorry, please. What was the second question?
Well, I guess you have basically answered the questions I asked. Let me
If
get
I
to...
may...
Yeah, go ahead.
Yes, please. If I may also use this opportunity to also speak with some of the issues as far as the Corporate Affairs Commission is concerned. I think this is a wonderful time and a wonderful opportunity for the Corporate Affairs Commission. It has a major and pivotal role as far as the economy is concerned. As a practitioner myself, I am not unaware of many of the challenges which it has had to contend with. I think there are certain things the C.A.C is doing right, but with this new piece of legislation, there are things that it must necessarily get right institutionally. So, for instance, the full optimization of this act requires that the C.A.C must have a robust information and technological infrastructure. I cannot speak as to the full extent to which it does have that. I know that there are glitches here and there, but that's a challenge that it definitely must now have to contend with. On the other side, too, for lawyers and the general public who has had to interact with the Corporate Affairs Commission, it's a welcome development that the law has also now introduced the Administrative Proceedings Committee, which means that many items which form points of grievances with the C.A.C do not immediately have to go to court. Rather, the law says that we must now go to what is essentially an administrative tribunal. And this places challenges on the institutional capacity of the Corporate Affairs Commission, particularly to ensure that decisions are given in a prompt manner and in a manner that is enabling of business and commercial activity as well, because all of these things, all of this law that has just recently been assented to is ultimately geared towards enhancing the ease of doing business. And I believe and hope that the C.A.C will be able to continue to play that role.
All right, thank you, Mr. Jabi. Okay, good enough. We have the C.A.C CEO there, Mr. Abubakar. Well, Mr. Abubakar, you heard what the concerns Mr. Jabi has raised. What would you have to say about that?
These are legitimate concerns, but I want to assure Mr. Jagua and the general public that C.A.C will be up to its responsibilities. We've started the necessary engagement to have a robust technological solution, even before the law was assented to. So this is work in progress. I agree that the present application does not cover the entire aspect of our operations. It only covers new registration. So very soon we'll deploy the post-registration model. And the good thing about technology is we are not doing anything new. Other countries have done similar things, and they have achieved more or less perfection on that. So all we need to do is to look at what other countries have done and develop something that will be consistent and that will meet the expectation of our clients and customers. So we are working on that, and our target is to have an end-to-end electronic solution before the end of the year. And as I said, for the Administrative Proceedings Committee, we will develop practice directions, we will develop rules that will govern the proceedings of this committee. And in doing that, I had earlier mentioned that we will not do it alone. We'll involve practitioners, company law experts, in the committee that will design all these processes and procedures. So we don't have the monopoly of wisdom and knowledge. But what I can assure Mr. Ajagua and the general public is C.A.C will deliver on this, and will deliver within the shortest time possible. Thank you.
And we will hold you to that, Mr. Abubakar. Thank you very much for coming on the show. Mr. Garba Abubakar is the Chief Executive Officer and Registrar General of the Corporate Affairs Commission. And, of course, we have the Managing Partner, Aid and Solicitor, Kunle Ajabe. Thank you very much, gentlemen, for being part of the show. All right, we'll take a break, and when we come back, we'll look at the outcome of the presidential policy dialogue recently organized by the Lagos Chamber of Commerce and Industry. To stay with us.